A very hearty good evening to Honorable Justice Rajshekhar Reddy Sir, Vice Chancellor Sir, Dr. Chandramouli Sir, Saurabh Bharti Sir, and Mr. Alok Prasanna Kumar Sir, professors, volunteers, and all the attendees. Before we begin with the inaugural ceremony, may I request the Vice Chancellor Sir to felicitate Honorable Justice Rajshekhar Reddy Sir with the bouquet. Thank you, sir. Now, may I request Saurabh Bharti sir, our faculty in charge for Moot Court Committee, to felicitate Mr. Alok Prasanna Kumar sir with a bouquet. Thank you, sir. I extend my warm welcome to each one of you to the inaugural ceremony of the 17th Nalsar Justice Bodhraj Sawhny Memorial Moot Court Competition, Nalsar's flagship and one of the premier constitutional law moots in India. I am Vanshika Sharma, hosting the inaugural ceremony on behalf of the organizing committee with my co-host Hasini. Nalsar has previously organized Premier Moot Court competition and has witnessed the participation of brightest brains from the law schools across the country. In keeping with this tradition, the university is organizing the 17th edition of the prestigious Nalsar Justice Bodhraj Sawhny Memorial Moot Court competition in collaboration with Justice Bodhraj Sawhny Memorial Trust in association with Vidhi Center for Legal Policy. The Bodhraj Sawhny Memorial Trust was founded in 1999 by late Mr. Digambar Sen Sawhny in memory of his father Bodhraj Sawhny, an eminent jurist. The trust aims to promote excellence in legal education, community health, conservation of the environment, and upliftment of women. The Bodhraj Sawhny Memorial Trust is working with the national law universities and law schools all over India. The trust supports scholars for higher education and legal studies with scholarship. We also thank and express our gratitude to Vidhi for the collaboration as associate sponsor. Vidhi is an independent think tank doing legal research to make better laws and improve governance for the public good.
It is with great pleasure that we announce the introduction of a panel discussion for the first time in this moot court competition. This edition marks a significant enhancement to the event, providing the participants with a unique opportunity to engage in a dialogue on pressing legal issues. Furthermore, we are deeply honored to announce the introduction of the Nani Palkiwala Award for the Best Speakers, a prestigious addition to our competition this year. We extend our heartfelt gratitude to Mr. Homi P. Ranina and the Nani Palkiwala Trust for their generous support and for helping us recognize and celebrate excellence in advocacy. This year's moot proposition, which focuses on the highly complex and highly relevant issue of delimitation, is drafted by Mr. Alok Prasanna Kumar sir and Ms. Ritvika Sharma ma'am from Vidhi Center for Legal Policy. Participants throughout the competition will engage with challenging legal and constitutional law questions, examining the intricacies of the electoral boundaries and representation. The moot proposition provides a valuable opportunity for a thoughtful exploration and challenges the participants to come up with creative legal arguments.
Without further ado, we have our Vice Chancellor Sir with us. Professor Sri Krishna Dev Rao is a distinguished academic and leader in criminal law and access to justice. With over 3 decades of experience, he has held prestigious positions, including Vice Chancellor of NLU Delhi and NLU Odisha. A Fulbright Nehru Scholar, he has contributed significantly to criminal justice, especially in preventing custodial deaths, and his insights were referenced in the landmark DK Basu case. He developed legal aid programs, including the Land Rights Paralegal Program and a diploma in paralegal practice. Professor Rao has also chaired the Ministry of Home Affairs Committee for Reforms in the Criminal Laws and was awarded the Kumarappa Reckless Award for his outstanding contributions in the criminology in India. He remains an influential figure in shaping legal education and reforms, representing India at international platforms such as the UNHCR Council. I would request Sir to share a few words with us.
Honorable Justice Rajshekhar Reddy Garu, my colleague Alok Prasanna, Vidhi. You know how Vidhi has pioneered legal research and advocacy in India. He's a co-founder. And my colleague Saurabh and friends. I appreciate all of you for taking an interest in participating in this 17th Bodhra Sawhny Moot Court competition. We were just discussing with Justice Rajshekar Reddy when we were the students in the old 3-year LLB model, 81 to 85. We never heard of the mooting. Over the years, what we have seen, amazing skills of lawyering have developed. Thanks to Professor N.R. Madhavamenon, Professor Upendra Bakshi, both of them have visualized the national law schools way back in 1980s. And now we have seen. So mooting is an amazing skill. Of course, you will learn the real lawyering skills when you enter into the court hall. But this is a preparatory skills. And I appreciate all of you for taking this interest and participating in this. I think 70 teams have registered and about 24 have been selected for this. 2 ideas, and then I'll ask other colleagues to interact with you. First, Bodhra Sawhny, I am very fortunate, Digambar Sen Sawhny, who instituted this first in the Nalsar and then NLU Delhi. So I am associated with the both. And Digambar Sen Sawhny was a son of Justice Bodhra Sawhny. If you Google, you will find Bodhra Sawhny was studied in Oxford and Cambridge, and also perhaps the first judge in the old pre-independent Jammu and Kashmir High Court. Old generational lawyers and judges are rare commodity. So that's what I have seen Digambar Sen Sawhny, his son, so passionate. He passed away, and they constituted in Delhi in this memorial trust, and we are happy that we are celebrating and we are also remembering Bodhra Sawhny and also organizing 17th. Lastly, thanks to Alok for thinking about another very interesting, fascinating problem, delimitation of constituencies. Every time BR-SMT moot problem comes out with something more provoking all of you. Of course, those who are in the 2 Telugu states will realize not only 2 Telugu states and the Chandigarh and Haryana. In fact, I remember when the whole idea of a separate Telangana state was coming up, some of us, we said, why can't a Chandigarh model? Anyhow, I leave it to you. And once again, I welcome to all of you. And please focus on your problems and forget about winning or losing. Perform. Dramatist, that's what, like how you will behave, and that itself is a winning. And congratulations for all of you for joining this, and all the best.
Thank you, sir, for your kind words. Now we have with us Honorable Justice Rajshekar Reddy, sir, who is also our chief guest for the event. Justice Rajshekar Reddy practiced predominantly in the High Court of Andhra Pradesh, handling civil, taxation, criminal, and constitutional law cases. He was elected as the Vice President of the Andhra Pradesh High Court Advocates Association in 2004 and served as Assistant Solicitor General of India from 2005 to 2009. He was also appointed as the Senior Standing Counsel for the Central Excise, Customs and Service Tax and designated Senior Counsel by the High Court in 2012. Elevated as an additional judge in 2013, he assumed charge as a judge of High Court of Judicature at Hyderabad in 2014, serving both Telangana and Andhra Pradesh. Now we would request sir to kindly address the gathering.
my dear friend Krishnadeva Rao, Vice Chancellor, Nalsar University, and Alok Prasanna Kumar, co-founder Vidhi, and Professor Saurabh Bharati of this university, faculty members, my dear young students. It is always, I feel at home, anything related to law, because I lived in law for so many years, for last 36 to 40 years. When I interact with lawyers or law officers, law students, come to any law college, I feel at home. It is homecoming for me. I remember those old days where I spent with my friend. We were not so vigorous in law. In fact, to say a few words, I've done my graduation in science. So I was not interested to pursue my studies in science. So what next is there? And in those days, they used to call law is the last resort. Now it is not so. Now it was being a first resort. So we joined law half-heartedly, completed half-heartedly, enrolled half-heartedly, practiced half-heartedly for some time. Later, we don't know, later it was I was attracted towards the legal profession after some time. So that was my journey. And you young students, now today's topic is moot court. We have not heard about this moot court, this name not at all when we were studying law. But fortunately, 2 hours was day college, 100 seats used to be for day colleges, 100 seats earmarked for evening colleges. At that time, they were evening law colleges. So we didn't have the infrastructure and building. So all 200 seats we used to have evening colleges. We were fortunate to have all lawyers who were practicing. They used to come and teach this drafting and pleading other subjects. They used to tell about the profession also. Theoretical aspects, professors used to teach us. So that was the advantage, because drafting and pleading. I remember drafting of a plaint, one KSRG Prasad advocate used to come, and though he is a leading advocate, he was interested in the law community. He felt it is so his social responsibility to train young law students. So I remember whatever he said as how to draft a plaint, how to draft a written statement, how to draft a rejoinder. So that was the advantage. So now, so in the year 1981, 1989, the Bar Council has introduced this moot courts, and 85 it has become part of curriculum, though it was there in England for 14th century and in US 18th century, and Harvard Law School adopted in 1870. So only we realized the importance in 1981 and 85. So the advantage is now I've seen, because as a lawyer I used to go to colleges as a judge for moot court competitions. In moot court competitions, they used to prepare very well, and I have seen youngsters arguing better than lawyers because they are trained. The moment I became judge, they also became advocates and they started arguing in the court for 5 years. And in High Court, people say we started at 5 years, and High Court they used to say you are fortunate because it took us 10 years to argue a case. And seniors used to give brief after 10 years. So because we didn't have the training. So as my friend was referring, I was gold medalist. In spite of that also, when in the first day I stood up in the court, everything was new. Public speaking. We are not exposed to public speaking. And public speaking is different from this arguing the case, because in public speaking, there is no opposition for me. Just you listen what I say. In courts, it is not like that. Your opponent will be there, judge will be there staring at you, and witness. Sometimes you have to face the witness also. You have to ask questions witness. So multitasking you should do. What happens even though you are a gold medalist or anything, you are topper in the college, when you go and stand there, you will not understand court procedures. So this moot court competition, nothing but mock courts. So you'll be knowing what are the intricacies, at least how to present a case, because you'll be given a problem, their evidence, other things may not be there, but as but some topic, you'll be only arguing on legal points. And what you'll be learning a lot, because presentation, how to present a case. You'll be preparing memorial, that's like written arguments. You'll be knowing all those things. Otherwise, first day you go to the court and start put a blank face sometimes. Inside your stomach, inside your head, lot of material is there, but how to put it, how to get it out is very difficult task. This moot court helps you. how to put it, whatever you have, what the language of law, especially presentation, oral advocacy skills. Many of you may not be exposed to public speaking. Even if you are exposed to public, I've seen many public speakers who come to the court, they can't argue properly because once they face, judge asks some questions, they're funk. And other side obstructs, always there will be obstructions. Your opponent will be obstructing. So in that obstructions also, you'll be able to speak. Your line of thought, your articulation, all those things you require. It's a multitasking. It's a very difficult task to be an advocate, but still we enjoy also. You enjoy thoroughly because you get a lot of satisfaction. You have to think on your legs. Whatever you read, sometimes judge may ask something out of somewhere, whatever you, sometimes irrelevant also. Judge wants to know in a different case. So he asks some question which is not related also. If you are thoroughly prepared and you should have that what you call stability, stand there and answer the judge. Sometimes we are not able to answer also. We may straight away say that because law is an ocean, any subject is an ocean. You are not expected to be a master in law or attain perfection. So you can simply politely say to the judge that I'll come prepared. And nowadays, youngsters I have seen, especially coming from law schools, other things, they are doing very well in the profession. And in Nalsar, other corporate law colleges, they used to go to corporate side. I don't say undermine the going to law corporates also, but nowadays gradually there because the environment in the courts is different. Little bit the pay master, other things compared to corporate colleges are different. But still you will enjoy after some time because when we joined the legal profession as a lawyer, for 5 to 10 years, there is not much of income. All our friends who joined in other public sectors, other where they used to earn a lot of money, and we used to feel that we are sidelined, and also we are not able to compete with them. But after some time, we were able to equalize, sometimes beat them also. And now communication skills in all these corporate colleges, you are doing internships, and Moot Court also, it gives a lot of opportunity. Networking, and also able to presentation skills, and on legs. So this you go number of 5 years, you are in 5 years law course. I think I am told that even first year law students are also allowed to participate. Now 24 teams have come, 72. I think 2 will be speaking and 1 will be researching. And even the law is not static. Though in law college, I am gold medalist, finish. I did not read anything, finish. I will become a very good advocate. No. Daily you should read briefs. However intelligent you are, you should go and read the brief thoroughly. And what is the latest law? Now in live law, several other things in net, other things you are more proficient because we didn't have this advantage. You can see which judgment later, yesterday's judgment, the Supreme Court judgment also, today's morning judgment also, while arguing case, judgment comes, just you can pass over and see in the net and cite the judgment. Those were the days when we joined, there was no such facility. And we were doubtful to cite also whether judgment is overruled or not. And we used to have digests, my friend knows. And we used to thoroughly search for every section of thoroughly search. And after so much of search also we don't know which is overruled also, because sometimes the judgment, it will be only up to 2022. When we are citing in 23, we do not know whether it is overruled. Now by a click of a button, we will know which part of judgment is it. It is when judgment deals with several legal points, only on one point if Supreme Court overrules, that is also very clear. In SEC, we used to get the orange, this part of the orange mark, saying that this part is overruled. So you are in advantageous position. I've seen youngsters when as a judge also, when they were appearing, especially for all these colleges, Nalsar and other things, they used to, when I ask anything, that they used to take a passover and go out and cell phone, they used to search and any material also. For a lawyer, you should know a little bit of everything. Knowing law is not sufficient. He should know a little bit of history, all subjects, because we will be dealing. Once I had to deal with the case dealing with anesthesia, where I was defending a lawyer who has killed a patient. So I had to read the science on this medical science also. Sometimes engineering. When we're dealing with tenders case, we have to know about something, it will be engineering. Some things we'll be deciding some about some art competition, something. We should read about that also. So a lawyer should be voracious reader. And these moot court competitions, lot of exchange of ideas. Different problems will be given. We will be interacting, countering different students. And you will know how to counter the, not that you are master of everything, but should at least know. So this is the advantage moot court has. I think now it has become regular part of your curriculum in all law colleges, including corporate and non-corporate also, because I have attended as a lawyer, as a judge also, several colleges. And students directly, we have seen earlier, very few, not even very few, at least in High Court, it used to take 5 years to represent a case for asking for adjournment also. But now I have seen, straight away from law colleges, they are coming and arguing very efficiently also. In arbitration, now I'm doing arbitration after my laying down my office, and youngsters, they are doing, both the youngsters, men and women, they are doing very well. So that is a training. They participate in moot court, they attend internship, they sit in the court. This is observation. While coming from my house, one student was accompanying me. He was asking how to develop oral advocacy. I said, nothing. When you are doing law, you have time, go and sit in the court hall. Join some advocate's office, you have time. But it's only by observation. Court etiquette, all those things. How to deal, how to address a judge. All these things we will be learning in moot courts. I think most of you might have participated in moot courts, and so even as a president of Judicial Academy, now what is happening now directly from law college also, judges are being selected as junior civil judges. And we have selected many from Nalsar also. And very few people, Nalsar and other corporate colleges, very few used to come as judicial officers, because it is a very cumbersome job. To be a judge is not an easy task. It appears from outside, but when you sit there, you will understand. After so many years practice, I used to see, when my name came in the newspapers, one of my client telephoned, sir, you have worked hard, now you read rest. I said, why? Your name has been recommended. I also thought like that only. Sit there, just hear and what they produce, then we reproduce, that's all. But after 2-3 months, I understood it is not very easy job. And a lawyer also, you should take decision, because client comes with so many of problem. He tells you from his birth to till the case. So you have to separate chaff from the grain and only present the grain. So you have to take a decision, stand. When you are a trial court lawyer, you have to take stand. All these things you will be learning by this moot court. Though there is a examination of witnesses, cross-examination is there, not there. So I introduced as the president of Judicial Academy, instead of lecturing, because the res judicata, you know, from net, you know, why we put just click what is meant to res judicata, you will get several authors, what is res judicata. In law college, you will be reading. Again, we in Judicial Academy also, we go and we will be lecturing. I said, there is no use. Only thing is, I told them, get old cases from disposed of matters in from courts and give them depositions, the issues, pleadings, plaint and written statement, and we'll ask them to write judgments. So judicial officers, apart from public speaking, we require a judicial officer who can write orders. So you should learn how to write orders. I've seen several lawyers who have become judges, they're not yet good writing orders. So it's also art, and also it's also practice. So all those skills, if you learn, and also now this is a part of your what you call resume. How many moot courts you attended, practical. Now everything experience. If you go for any job, you ask experience. Here in law, what is the experience? While in law college, participate in moot courts. It's a practical aspect of the preparation of law, because you learn many things there. So moot courts, don't miss, and whenever you get a chance, attend. You know, outside also, law colleges also will be conducting, and it will be useful by the time, because I have seen several people directly arguing in the court. I don't say you should not join Senate's office, because still lot to be learned. Some tricks of the trade, and what not to ask and what not to, and how to, many people think that judge doesn't know. But we're sitting, he will be writing orders. He will be having ego. So you should see that he is in a comfortable position. Even if you know more also, you should not appear to be like that. You should pretend the judge knows more. All those things, tricks you learn in moot court. This is mock court. In Judicial Academy also, we train them. So here, judge, sitting here, judge, you will not be writing judgments, but you will be judging your career, how you perform, how you present, and what your how testimonial, how is your what you call drafting skills, all those things. What is the practical knowledge? And sometimes in advocacy, the silence is also best part of. It's not that the client is there behind you go on. Sometimes it's not required. Silence is best part of advocacy. All those things, skills we learning here. Because for coming to moot court, you thoroughly read because thorough conduct research. And team spirit also. As an advocate also, singly sitting in your office, you can't do. You should have assistance of juniors, clerks. And also you should be able to cope up with, cooperate with judge also. You should be kind to other sides in the sitting in a court hall also, as an advocate, as a judge also. These aspects you learn in moot court. So I'm glad that you have come for participating in this prestigious Justice Bhojraj moot court competition. And I wish you all the best. And I'll congratulate and also wish you all the best. Thank you.
Thank you so much, sir. Your words were truly inspiring. We hope to host you again sometime in the near future and have an opportunity to learn more from you. Today, we also have with us our distinguished alumni, Mr. Alok Prasanna Kumar sir, co-founder of Vidhi Center for Legal Policy and currently team lead at Vidhi Karnataka. His areas of research include judicial reforms, constitutional law, urban development, and law and technology. I would request sir to share a few words with us.
Thank you. Justice Rajshekhar Reddy, former judge of the Telangana High Court, Professor Sri Krishna Deva Rao, VC of Nalsar, and my former teacher, Professor Saurabh Bharti, Mr. Chandramouli, and Professor Aditi, thank you so much for agreeing to be part of the panel. It's a pleasure to see you here, and I look forward to hearing you on this topic later in the evening. My Vidhi colleagues who have taken time out and joined me on this fun errand, they have willingly given time for. All the finalists, I would say, of the moot court, if you have gotten to this stage, you have cleared a very rigorous round so far of the writing the memorial and having it evaluated, and now the true test begins. And fellow Nalsar students, I say fellow Nalsar student because you know that I'm one of you, and I think once you're a Nalsar student, you never stop being one. You just add other things to your resume eventually in the end. Thank you so much once again for being here for this 17th edition of the Bodhraj Sawhny Memorial Moot Court Competition. To the stories that Professor Sri Krishna Deva Rao mentioned, I will add one small story myself. I was in the 5th year in Nalsar, and I was a member of the Moot Court Committee when the Vice Chancellor, then Vice Chancellor, Mr. Ranbir Singh said, here are somebody from the Bodhraj Sawhny Trust. They want to conduct a moot court competition. I've said, yes, now go ahead. So we were like, wait, you mean in next semester, right? He said, no, in 1 month from now. Those of you who have ever organized a moot court competition will know it takes a minimum of about six to 7 months to put together a moot court competition from scratch. And we were told, you'll manage in 1 month. Don't worry about it. And we did. I was on the organizing committee, of course, along with 4 of my other colleagues. And I think we were in some ways driven up by the enthusiasm and passion of Mr. Bodhraj Sawhny's son. We were, of course, so ignorant, we didn't know who Justice Bodhraj Sawhny was. We thought he was the old gentleman who was sitting opposite us, telling us to organize the moot. Then we realized, no, this is his son. And then all those pieces started falling in place, and we realized, yes, okay, that a man of his age would be so interested, so passionate to want to come here to Nalsar and say, please set up this moot court competition. I really want to honor my father's memory in this particular respect. So I'm very glad and I'm very grateful that the small thing that we started in 2008, which we somehow managed to organize and bring to a successful conclusion by the seat of our pants, I would like to say, has now become this well-established, well-respected, and seriously rigorous moot court competition, which I can go anywhere in India, in any law school, and say B.R. Sawhny, and they know exactly what I mean. They know exactly how important it is and how meaningful it is and how much of a legacy it is. So I'm grateful to all of you, not only for participating, but also for the students of Nalsar who have kept alive, along with the administration of Nalsar, this particular institution and practice. And I'd like to give you all, and let us give everyone a round of applause for having gotten this important initiative to this stage. There was a reason why it was a constitutional law moot. And if you go back and look at Justice B.R. Sawhny's judgments, you will find that apart from being, of course, a judge of the Jammu and Kashmir High Court at a very pivotal time in India's history, he was one of the first few to start thinking seriously about this new constitution that has come into the picture. What does it mean for us? What does it tell us about the state of governance and power in the country? But more importantly, I think constitutional law is never about a mathematical solution to a problem, right? And I sometimes feel slightly awkward calling it a moot problem. And I generally try to use the word moot proposition, because there's never one answer. If it is one answer, then it has failed as a moot problem. You're supposed to be able to argue both sides without any one side feeling like this is too easy. We have all the precedents, all the principles, all the interpretations set for our side. There's nothing more to argue here. And that is very true of constitutional law itself, right? When a moot problem is set, which is sufficiently balanced that either side could prevail at the end of the day, it reflects what constitutional law is. Constitutional law is essentially a conversation that we as a nation are having with ourselves. We sometimes outsource that responsibility to lawyers and judges because they use technical language. They use a certain kind of vocabulary, metaphor, principles. But we all agree that our arguments on the future of our nation will be made on the touchstone of the Constitution. And this is the most important thing that I want you all to take away. When you are participating in a constitutional law moot court competition, it's fantastic for your resumes. It's great for your knowledge. But what you're really being part of is a very important conversation in our country. And a good moot court problem, I believe, or a good moot court proposition, I believe, will find a way to make that conversation current. For better or worse, we have seen that in the last year or so, the Constitution has come to take center stage in India's politics in a way it hasn't for maybe 40, 50 years. I'm not old enough for the times of emergency or anything like that, and I can only go by news reports and so on. And I'm not going to go by pop culture reenactments of the emergency. But somewhere in our political discourse, we have rediscovered the Constitution. That's a good thing, and that's a good starting point. It's great when politicians, political parties, movements, activists hold dear to the Constitution, hold dear to the principles of the Constitution and the preamble of the Constitution. But that's step one. Step two is about applying it to the problems that we face today in our country. And when I say applied, I don't mean that you just open up the Constitution and you'll find a solution. That's not what I'm saying. What I'm saying is that the Constitution provides us a framework, a set of guiding principles, a set of values to tell us how to find solutions for the problems that our country faces. And with this spirit in mind, we consciously chose the topic of delimitation. One, of course, because we at Vidhi believe this is an area which doesn't have adequate research and needs much more research. So we have put out some of our original thinking on this. Please do check it out. But secondly, we believe this is an issue that is going to become very central to the future of our republic in the next decade or so. I would even say the next 5 years or so. Because what delimitation does, and in some senses, you could say it's just a pure mathematical exercise of drawing boundaries around, large maps and figuring out how many people should go where. Delimitation is a fundamental aspect of how democracy works under our constitution. How much do we really value the idea of one person, one vote? But our constitution is not about one value. Our constitution is not about one principle, one core thing that if you stick to it and everything will be fine. Our constitution has this network of values, each of which feed into each other. One person, one vote sounds great. It ensures equality. But what about diversity? What about federalism? What about the idea that those who are not equals in reality should be made equals in the future in some way? These are all ideas our constitution encapsulates, has, contains, gives details, gives more information about. But we haven't put it all together. And when I say we, I mean generally lawyers, thinkers, citizens. We haven't yet put it together to come up with a way to address this challenge which is going to face us in the next decade. I won't take too long on this because there is a panel discussion where all of this will be gone into much more detail, but very shortly, we are at that stage in our country's history where some very crucial questions will have to be answered. And one question will be, if one person, one vote has to be adhered to, what happens to those regions of the country which are less populated, but play an important role in the national economy? Conversely, if we say that these regions play such an important role in our national economy, do we give up the principle of one person, one vote? How do we ensure that representation in the parliament, in the legislature, is not just a reflection of population? Of course, it should be. But what about diversity? What about opportunity? What about acknowledging the extremely different societies that constitute this country? Because that is one thing which we cannot deny, right? It's a fact which stares at us, and it stares at us as we look at each other. We know diversity is fundamental to this country. It is what makes India. For 75 years, we have found a way to manage our differences and move forward. Just because we've gotten here, the task hasn't gotten easy. We're going to keep coming across new challenges, which ask us, how are you going to manage your differences and move forward? And this is the challenge that delimitation places before us. You've all done your research. You've all written your memorials. You've got all your arguments written down, and your notes and your chits are all ready for arguments starting tomorrow. But irrespective of how far you go in this moot court competition, my request to you, all of you, especially the participants and also the others who have had a chance to look through this area, is to think about how you can contribute to this conversation. Because there are very few people who are bringing the constitution into this discussion. The discussion is happening at the level of my state, your state, our stress for the future of the republic. That is not how the constitution expects us to address these challenges. By participating in this moot court competition, by having gotten this far, I hope you see yourselves as not just students who have taken part in an interesting academic exercise, but future lawyers who've had a chance
to engage with one of the most important issues facing the Republic in the next 30, 40, maybe 50 years. And whatever ideas you've developed, whatever thinking that you've developed, whatever information,
knowledge that you have obtained during the course of this moot court competition, you will use to further the conversation about the Constitution in the context of delimitation. So, with those few words, I'd like to thank you all, those of you who are here, and also those perhaps who have signed up, participated, but didn't make it to the final rounds. Thank you all for participating, because I believe that in all of this, each of us who has learned more, who has applied our minds a bit more to this issue, have contributed a little bit further to our knowledge improving on this important issue of delimitation. And I wish you all the best. I hope I get to hear some of your thoughts and your takes in this particular matter in the course of the moot court. And of team in terms of the speakers will win. But I would urge all of you, those of you who are participating, to please see this as an opportunity to take part in a much larger conversation that will determine the fate of the Republic. Thank you so much.
Thank you, sir, for your inspiring words. I would now like to request Professor Saurabh Bharti, sir, a faculty coordinator for the Moot Court Committee, to address the gathering. Professor Bharti specializes in intellectual property laws, and he's an assistant professor at NALSA.
Okay, I don't want to hold you for too long. I'm sure you're waiting for the panel discussion and then eventually to start preparing for your competition. In my capacity as the convener, faculty convener of the Moot Court Committee, I take the honor of welcoming and at the same time extending my gratitude to Justice Rajshekhar Reddy. I also, sir, first of all, thank you for inspiring the students, with respect to mooting activity and also highlighting the nuances of good advocacy. I also thank our Vice Chancellor, Professor Krishnadev Rao, for continuous support for mooting activities at NALSAR. I'll take this opportunity to also announce that although NALSAR organizes 3 moots in a year, we have recently also signed an MOU with a law firm in Bangalore, KSK Partners, and we are coming up with a 4th mooting competition in the area of commercial laws. So if some of you are interested there, please keep checking our website for the announcements to be made there. So, sir, I thank you for all your support for the mooting activity. I also welcome Dr. Chandramouli, my friend Alok, and other honorable guests from Vidhi. So this is our 17th edition, as has already been highlighted. And as faculty convener, it is a matter of happiness for me to see that continuously we have maintained robust participation. As Honorable Vice Chancellor had mentioned, this year also we saw 70 teams registering, and then eventually 24 teams are sitting in this hall who are ready to compete with each other in a physical, argumentation sense. So it's a great sense of satisfaction that we are maintaining the quality of the moot, that it is, attracting so much of attention across the country. But while I am appreciating or sort of congratulating, myself that, okay, as a mooting body at NALSAR, we are doing this great. I think the credibility of this competition is also greatly dependent upon the support we receive. And in this case, support from Vidhi particularly. It is the quality of the problem. For example, as Alok has already said, you can choose to draft a problem in any manner whatsoever, but if you take that exercise seriously, then it's a damn serious exercise, both in terms of the nature of the problem as to does it give enough opportunities to people to explore new ideas, and also the area you choose, which is of relevance in the contemporary sense of it. So I thank Alok and Ritvika for drafting such a challenging problem. And for Alok, I would say that it would be unfair on my part to thank him only for drafting the problem. Although I must concede, as I've said, drafting the problem is by no means a small job. But for Alok, I would say, because he's been associated with this moot for a long time now, that his presence itself is a matter of confidence for the student body, the organizing committee and the MCC. And therefore, I think I extend my gratitude to Alok in that sense. This time we have also innovated. You have a panel discussion, as has already been said. I wish our organizing team led by Masad okay, and Moot Court Committee also. I'm sure they would leave no effort, short of expectations when it comes to delivering to what you expect, both in terms of hosting you and also in terms of the competitiveness of the competition, right? And at the end, of course, I cannot leave the podium without thanking our sponsors, which is Bodhraj Sawhny's Trust. The word sponsor is a very transactional word, so therefore I should rather avoid it. I think it's the support they are giving to us in organizing such a wonderful academic event, where the expectations are nothing but academic enrichment of the participant and also of people who are going to judge and be part of it in one way or the other. And finally, before leaving, like I always say in all my sort of inaugural addresses, all of you would make an attempt to win the competition. Don't fail to win the friends. With that, I wish all of you all the best.
Thank you, sir. With this, the inauguration ceremony comes to an end. I would like to extend my gratitude and thank Honorable Justice Rajshekar Reddy, sir, for taking out his precious time and gracing this ceremony with his presence. We do note your years of experience, sir. I would like to extend my gratitude and thank the Vice Chancellor, sir, for his constant support, without whom this event would not have been possible. I would like to extend my gratitude and thank Alok, sir, for his precious presence. Thank you to our faculty coordinator of our Moot Court competition, Saurabh Bharti, sir.
Last but not the least, I would like to thank the organizing committee for their hard work and Justice Bodhraj Sawhny Memorial Moot Court competition has been a legacy, and we wish to carry it forward for a successful 17th edition. Before we close this ceremony, I have a few words for the participants. The organizing committee for the next 2-3 days would be around for your help and ensure that the best is provided to you all. The Moot is not just an event to win, but also a great opportunity to learn. Happy memory and lots of learning. Happy mooting.